California's well-intentioned open meeting or sunshine laws were enacted to ensure more open government. Is it possible that overexposure to the sunshine has made government decisions worse? That is the subject of a new report from the nonpartisan Little Hoover Commission. Our guest is the executive director of Little Hoover Commission, Carole. Unintended consequences. Do open meeting laws undermine good government decision-making?
Additional funding for the Maddy report made possible by a grant from The Wonderful Company, harvesting health and happiness around the world, and by Kaiser Permanente. Thrive. From the California Channel at the State Capitol and the Maddy Institute, it's the Maddy Report, with Executive Director of the Maddy Institute, Mark Kepler.
Have California's well-intentioned open meeting laws actually made government decisions worse? That's the subject of a new report from the nonpartisan Little Hoover Commission. We're fortunate to have the Executive Director of Little Hoover Commission, Carole, as our guest. Welcome.
Thank you. I'm happy to be here.
Well, first, just tell our audience a little bit about the Little Hoover Commission. What exactly is its role?
Sure. We are a 13-member body. We have 4 legislative members and 9 members of the public. They're appointed by the governor, legislative leadership, and our mission is to make state government more efficient and effective.
Period.
Yeah.
That's good, right to the point. So let's talk about this recent examination of California's open meeting laws. What prompted that?
Well, it's actually kind of an unusual story. We were doing a hearing in April of 2014, and the topic of the hearing was energy governance. We were talking to the state's 3 entities about how they work together to make sure our lights stay on and make sure our rates stay affordable. We had a panel that included a representative from the Natural Resources Defense Council, a Berkeley professor, and an economist. And our commission said, you know, you work with these different bodies. What's your opinion? What are the obstacles? And sort of out of the blue, the representative from the Natural Resources Defense Council says, well, if you really want to fix things, if you really want to make things function, you have to fix the Bagley-Keene Act. And he went on specifically some changes that were made 6 years ago that prevent people from being able to talk.
And Bagley-Keene is what?
Bagley-Keene is one of 2 open meeting acts in the state. So we have the Bagley-Keene Act, which governs state boards and commissions, and its companion Brown Act that governs city councils, school boards, things like that.
And they said you got to fix that law.
Well, fix a fix that was made in 2009.
Fix a fix.
Mm-hmm.
Okay. So the result, I guess, when I was reading your report, they said that the result was that these 5 CPUC, that's the Public Utilities Commission,
mm-hmm.
is that right? Board members largely stopped talking to one another about issues regarding multi-billion-dollar decisions on some of the state's most complex matters. Why did that happen? Why did they just stop talking to each other?
Well, it was this amendment that happened in 2009, and instead of just having that public boards and commissions couldn't deliberate or make decisions, they added the words they could no longer discuss. You can't discuss anything that might come in front of your body. So what the representative at our hearing was saying, you know, it's the Public Utilities Commission. We also were hearing from the Energy Commission, but it actually applies to all state boards and commissions that people can no longer discuss without being in the public light.
So you can't discuss anything.
Anything that might come under your purview,
in your jurisdiction, correct?
Which is very broad.
Which is not necessarily what's on the agenda for that next meeting.
No.
It's anything that your agency deals with.
Right.
That's pretty broad. So what did the witnesses say what did that do to the ability of the CPUC to make quality decisions?
Well, again, it's CPUC as well as the other boards and commissions, but it actually drove down the decision-making into the dark. So the commissioners themselves couldn't speak, but the staff could. So the knowledge and the decisions are now being made in the dark. So instead of greater transparency, there's less.
So the staff, which is unelected,
Right.
unelected bureaucrats,
right.
They're then making the decisions or talking to each other, but the elected people aren't.
Correct.
It's kind of becoming I assume siloed decision-making. No one commission member talks to another commission member.
Correct.
Until they're at the panel. And then I'm thinking also, then who has knowledge of where these people are going? Probably interest groups and lobbyists who talk to each of the individual 5 members are actually going to know what's going on in that board and panel before the members on the panel actually know what's going on.
That's exactly right. That's exactly how we found it. We felt like the lobbyists were like bees pollinating flowers. They'd go to Commissioner A, Commissioner B, and they would know everything that was going to happen. One of the public utilities commissioners said he walks in the meeting room, everybody there knows exactly how the vote's going to go. Everybody but him and the other 4 commissioners.
Can you go up to the lobbies and ask them how's the vote? No, I don't want to ask that question. Well, when we come back, we're going to talk about the why, what, and how of California's open meeting laws. That conversation when we return. This is the Maddy Report. California, like many states, has passed open meeting or sunshine laws to ensure that certain government proceedings and decisions are made open to the public. Our guest is Carole, the Executive Director of the Little Hoover Commission that recently issued a report on California's sunshine laws. So you provide some a brief introduction of California's open meeting laws?
Sure.
I'm wondering what they cover and what is their underlying purpose.
Okay. So there's 2 laws. The Bagley-Keene Open Meeting Act, that governs state boards and commissions, and as I said earlier, its companion, the Brown Act, covers locals, city councils, board of supervisors, school boards, and their advisory bodies as well.
But these laws have been around for a long time. For example, the Brown Act was signed into law by Governor Earl Warren back in 1953. So this has been, and even the Bagley Act, which became known as Bagley-Keene later, the local government law you were talking about, was signed by, surprise, surprise, Ronald Reagan in 1967. So these laws have been around for a long time.
Absolutely, and they're good laws, as they were originally conceived. You want the public essentially to have a role at the decision-making table. That's what the Open Meeting Acts are all about. It means when you're going to have a meeting, you put out an advance notice, you let people who are interested know, and you post it on your website, you have your agenda, the public's able to attend, and the public's able to participate and make comments on things that are going to be decided that affect their lives. So it's very appropriate that we have these Open Meeting Acts.
But those laws have been amended over time, right? So some of the amendments have done what, and some of the court decisions have done what, so it leads us to where we are now. What's happened over time since those laws were initially passed?
Sure. So in 2006, there was a court case. It was City of Fremont, Wolf versus City of Fremont. And it was a case, it was a local government case where officials had talked to each other about a topic, but then the topic never came on to
the topic, I actually wrote that down. It was a topic about the number of police responses to something, and the city manager decided that they were going to do fewer police responses to this particular issue, and then he went around, my understanding is he went around and talked to each of the city council members to get their support.
Exactly.
And there was something, I think it was called a serial meeting?
Yes.
What's a serial meeting?
A serial meeting would be if Commissioner A talks to Commissioner B, and then Commissioner B talks to Commissioner C.
So they don't all get together, but
right.
It's a chain.
And it can be done electronically now, too.
Okay, so, and I think my notes here said they began limiting responses to home invasion alarms. That was the issue. And so the city manager goes and talks individually to these folks, and so that leads to a lawsuit. And
right.
What does the Court of Appeals in this 2006 decision, what do they say?
So they said that because the decision was never acted on, that it wasn't illegal. And so what happened was that kind of threw the Open Meeting Acts into disarray. So then it was very murky as to who could talk to who and when, and if it's going to be on the agenda or not. So everybody at that point in time generally agreed that that court case led to greater confusion. So the people agreed there needed to be a change, an amendment. And so that's what they did in 2008, and that's where people got together, the League of California Cities with the California Newspaper Publishers Association and others, and they said, what can we live with, how can we word this so we get back to where we were before, so people understand what they can and can't do. But what they did that was a little bit beyond what had happened before was they added those 2 words, to discuss. And for a lot of people, for the lawyers, that changed everything.
And to discuss any subject matter within that particular agency or council or whatever's jurisdiction.
Right, so you can imagine a city council, how many different types of things could possibly come up in front of the city council. So they just don't talk to each other. It's, they've been advised, and rightly so, by their lawyers. Their lawyers say, just don't talk to each other outside of a public meeting. And so they don't want to go to a social event together. They don't want to be seen at a conference that somebody holds to provide information. I even heard recently that a lawyer advised an advisory group to a commission that they couldn't even use a doodle, which is that online application where you can set meetings, so you check, are you available on Friday or whatever. And they were told they couldn't even doodle with each other.
That's a lawyer being overly cautious, but truth be told, lawyers are supposed to protect their clients, and so they are by nature risk averse. So does the law, the way you seem to be describing it, does it include these informal discussions?
Absolutely.
And so elected officials then, they're not allowed to bounce general policy issues off their colleagues. They're not allowed to learn from each other. They're, it seems like these things would have an impact on their ability to draft good policy and to compromise to draft good policy.
Absolutely. On the one hand, like if you've got something like the Public Utilities Commission or the Energy Commission, they're deciding these multi-million, multi-billion-dollar issues. And often they have various dockets going on different topics. So you might have something on solar going, you might have something on demand use and rates, all going at the same time. And these different commissioners are all working on a piece of it, but they can never have even a generic conversation. So like, what do you think of the trends in the solar industry? That they could have that with anybody other than other board members.
Okay, so I want to talk about something else, these special rules regarding ex parte communications, and those are private one-on-one conversations between key government decision makers and someone.
Right.
So the California Administrative Procedures Act says, listen, for adjudicatory matters, if it's in front of a judge, one party can't talk to a judge without the other party present. And that makes sense.
Right.
But agencies also do rules and regulations, and ex parte communications are permitted when they're listening to stakeholders saying, well, how do you feel about this new rule? What are your thoughts on that? I think everybody agrees that judges shouldn't be talking to parties individually, but what about agencies talking to stakeholders about regulations?
Sure, so we kind of put the adjudicatory aside because there is general agreement, but when we looked at other ex parte communications, we actually we're kind of swimming against the tide this year. You had the PUC and PG&E, who is their regulated the regulated body, so the regulator with the regulated, having these secret communications via email and whatnot. So as we were doing our study, all of that was exploding in the press, and people were outraged, as they should be. But where we saw it was, so there was a rush to try and tighten the rules. How can we limit ex parte communication? And our feeling from our commission standpoint was, people are going to break the law. You tighten the rules, and the only people who are going to obey the rules are the ones that are already obeying them. And now you've just, tied their hands. They can't learn anything. They won't know anything. We even historically did work 8 years or so ago. We were looking at water boards. And we actually said that the regional water boards were making ill-informed decisions because they couldn't talk enough. Their rules were too strict, and we suggested they loosen them. So we're kind of coming down on the side of there is a role for communication between private parties, as long as others are aware that these conversations are happening. Okay,
well, thanks for that overview of California's open meeting laws. We're going to talk a little more about the downside of open government in a moment. This is the Maddy Report. So can you do too much of a good thing? Has the decades-long crusade for open government overreached and begun to obstruct good government? We're talking to Carole with the Little Hoover Commission that recently issued a report on the unintended consequences of California's open meeting laws. And we were talking earlier about these two words, to discuss, that were added to this 2009 amendment to the law, and it's been fairly problematic, hasn't it?
Yeah, absolutely. People don't talk to each other. And so it limits the information gathering, and it makes the decision making, as I said, it drives it back to the staff level.
But yeah, so it's less transparent, not more, and that's obviously a problem. So in your report, you also conducted an informal survey of elected officials, and you were very careful to say this is not statistically valid, but what were their feelings about the new law?
Sure. So I want to preface that by saying why we did the survey. So as we were, talking about the Open Meeting Acts, we kept getting elected officials, local officials that would call us, and they would want to complain off the record about how hard it was, how they couldn't.
Ex parte communication.
Yeah, and that they couldn't. They were making ill-informed decisions, but they wouldn't. For the most part, we've eventually found a few that would go on the record. So we said, well, are these just a few people who are complaining, or is this widespread? So we conceived this idea of doing the survey. We had, like you said, it wasn't scientific. We had about 270 responders. And across the board, more than 2/3 of them felt that, yes, these rules were making it difficult for them to make informed decisions, and that they thought that that it warranted a reform.
Some kind of change. And so ex parte communications, there was some discussion, I think you said, that most people felt that they were helpful as a general rule. And well, not in adjudicatory matters. We have already decided that that's off the table.
Right.
But in terms of regulation, hearing from stakeholders is a good thing because it refines those regulations and makes them better?
I'd say there was agreement on my commission, but I think, again, because of a lot of the scandals that were going on in the past year or so, a lot of people felt like there shouldn't be conversations at all. And we disagree with that. We feel like there's a time and a place, and as long as rules are followed, then it's something that's helpful to somebody who's on a board or commission. And it's usually the ones that deal with complicated topics like energy and water.
Yeah, and we also talked earlier about the fact that these open meeting laws can sometimes drive down decision-making to the staff level because the council doesn't want to talk because they're worried about a lawsuit. Let me kind of switch gears a little bit here and talk about these gadflies that we often see at school board meetings or city council meetings. They stand up and talk about every issue. Sometimes it's relevant, it seems like. Sometimes you wonder, what are they talking about? It seems like California's open meeting laws appear to permit this kind of abuse, frankly, of the public comment period. How do you deal with that issue, frankly?
Well, we saw it across the state, but we found the larger the venue, the larger the problem. So I would challenge anyone to go online and look at an LA City Council meeting and come to a different conclusion than we did. They had a dozen or so people that, according to some of their council members, show up every single meeting. They speak 1 minute on, it doesn't matter what the topic, they find a way to kind of sort of make themselves relevant. They are obnoxious. They say things that are derogatory about the elected officials. They say things that you wouldn't want a fourth grade class to go and observe. This is a public process. It's that bad.
Democracy is a messy thing.
But there's a person who wears a red Klan outfit there, and they ramble. And what happens is exactly the opposite. The people who really have something to say, the person who's, whether it's we're going to put a hotel down the street from you or we're going to, add more bike lanes. Well, the people who this is going to affect and really care never get to say because it goes on forever. And they're so disgusted by the people who are abusing the system that the real citizen doesn't get to say anything.
Mm-hmm, yeah. When we talk about these changes in laws and what's necessary, if you talk to proponents of open meeting laws, the media, frankly, the newspapers, and those, they're saying, listen, there's nothing wrong with the law. What we have here is some overly cautious attorneys advising city councils and school boards they can't do anything. And the law is really much more flexible than that. Isn't there some truth to that argument that it's really these lawyers that are making their clients overly cautious?
So the argument that you just raised, we heard over and over again. We included the California Newspaper Publishers Association, Californians Aware, all of those types of organizations. And we want the same thing. We want open government and transparency. But what we heard was that the lawyers are advising their clients because they don't want them to get sued. And in the case of the LA City Council, they have some of their advisory bodies who have tried to remove some of these people who were the gadflies. They've been sued and they've cost the taxpayers a lot of money.
And the reality is that is a lawyer's job, right? A lawyer's job is to protect their client from being sued. So they do have a tendency to be risk averse,
right?
And tell their clients, no, don't do that. You could get in trouble. And you saw that.
Yeah, and then you have the people who are on the boards and commissions, the ones that I've mentioned that make these multi-billion-dollar decisions. They don't want to do anything that's going to cause that decision to get dragged through a court. So they follow what the lawyers say and they don't talk to each other.
Well, interesting discussion on the unintended consequences of California's open meeting laws. Well, can we have both open government and effective government? That conversation in a moment. This is the Maddy Report. One premise behind California's open meeting laws is that government decisions made in the public are better than those made in secret. A recent report indicates that that assumption may not be entirely correct. How do we overcome some of the problematic and unintended consequences of California's open meeting laws? We're talking to Carole with the Little Hoover Commission about a recent report they issued on California's sunshine laws. So how can we change the law to encourage more, not less, transparency, which was the intent of the law?
Absolutely. Well, we came up with what we thought was a very conservative and minor fix that would go a long way. So what we suggested was both Bagley-Keene and the Brown Act be amended to either remove those words "to discuss" or just to clarify that it was okay for elected officials and people on boards and commissions to talk to each other. As simple as that. They can talk to each other. They can't deliberate. They can't form a consensus. They can't decide, but they can share information.
It's amazing we have to have a law to say that they can talk to each other. And the other thing, too, is that word, on any matter, that word "any" is such a big word in law. Any matter within your jurisdiction, boy, that really that probably needs to have some thought there as well. Well, what about making the public's business more, not less democratic? I mean, one of the things we talked about was these decisions are being driven down now to the staff level. These are unelected people as opposed to the council or board level.
Exactly. They're happening in the dark. The people don't have a spot at the table. It was very frustrating because we felt as if this was done with good intentions to clear up something that had become murky as a result of a court case. But the end result was that suddenly nobody was talking, and so the staff had to do it. So the staff know a lot, the staff make a lot of decisions, and the board members or the council members show up and vote. The public doesn't know what's going on. They have less information.
You know, things sometimes sound good in theory,
yeah,
but then in practice you realize, oops, the unintended consequences. So let's talk about ex parte communication. We talked about that a little bit. Those are those communications, those private one-on-one discussions. Again, not talking about adjudicatory matters, we're talking about informal rulemaking. Is there a way that some changes in the law should be made to allow for ex parte communications and rulemaking, so stakeholders can come in and talk to an agency and say, hey, this law is going to, or this regulation is going to affect us adversely this way?
Well, over the course of our study, there was a lot of activity trying to rein in some of the ex parte laws. And so we wound up saying they're okay as is. And each entity, whether it's the Utilities Commission or whether it's the Air Board or whether it's the Coastal Commission, they have subtle nuances. So we didn't want to have a one-size-fits-all that, here, do this. But what we generally said was keep doing ex parte. It's important, but there was an opportunity for more transparency and maybe more accountability. So in terms of maybe you want to put more stuff on your website as far as what was said. A lot of times you'll have this sort of, party A talked to Commissioner B and they talked about solar energy. Well, that doesn't really tell you a lot. So there's more that they could do.
So, for example, they could also add, what was their argument? What was the position that they argued?
Exactly.
And that gives a little more disclosure for that.
So we felt like there could be more of that.
Okay. What about helping make public officials' decision-making better, more informed? Are there changes in the law that we could have that would help to make those decisions a little more informed?
Well, again, it's our recommendation, let's just go back to where we were before the murky court case. Let's go back and allow people to talk to each other.
Because one of the things, when you hear these discussions about commissions, a lot of people that are on these commissions have expertise in different areas.
Yes.
And one of the arguments that I've heard is that you want people with different expertise in different areas to cross-fertilize, to talk to each other, and that would result in hopefully a better decision.
Exactly.
As opposed to silo decisions.
Yeah, you look at the Energy Commission and they're selected based on expertise. So that's the whole reason they designed it that way.
Yeah, that's a great example. Now let's talk about decorum. We were talking earlier about these gadflies at public meetings. What can be done to improve the decorum at local government meetings?
So that was a really tough question because, again, democracy is the cornerstone, having public participation, allowing people to make comments on issues that are going to affect their lives. At the same time, you have this small group that abuses the system. The legislature provides an example. If there's somebody who is out of line, they can be escorted out of a legislative committee room. And so I don't think that the locally elected officials should have to put up with something that the legislature doesn't have to put up with. So what is the exact sweet spot on how do we rein in the abuse while making sure that the public is able to make comments? I think that's something that the legislature could provide a model.
The legislature could look to itself.
Yes.
All right. Well, I want to thank you for those recommendations on how to promote open and effective government. Our guest has been Carole D'Alia with the Little Hoover Commission. Thanks a lot again for joining us.
Thanks.
If you want to stay current on state and local politics, you can follow the Maddy Institute on Facebook, Twitter, or log on to our website at maddyinstitute.org. This is Mark Kepler for the Maddy Report. Thanks for joining us.
The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect those of the California Channel or the Maddy Institute. If you'd like to share your thoughts about the points and opinions expressed on the Maddy Report, visit our website at maddyinstitute.org.